SJC-13382, Matthew Sutton and another v. Jordan's Furniture, Inc.
May it please the court. Julie Brennan on behalf of Jordan's Furniture. I'm sorry?
Sorry about that.
In the oral argument in this court, in the Sleepy's case in 2000, Justice Kafka presented a hypothetical question to the attorney representing the plaintiff in that case. The attorney is with the same law firm that represents Mr. Sutton in this case. And the question was, Sleepy's could have easily created a draw that met your requirements, right? They could have said, we will give you a draw that is the minimum wage times 40 and overtime at 1.5, and we wouldn't be here, right? That is the Jordan's pay plan.
Well, is it really? Because the subtraction issues there's three parts to the Jordan's pay plan I think are interesting. One is the difference you just pointed out, that the draw there, unlike the draw in Sleepy's, which is $125 a day without a breakout, this one had a breakout. But there were two other parts to this. One's that you have to pay everything back. And if you don't get a commission, either the beds aren't selling or you're not a good salesperson, you owe the money back. That wasn't the case in Sleepy's. There was no money owed back. And secondly, in footnote 8, which you do have something you don't have to pay out. If you work on particular holidays, you get that time and a half, and it's not a subtraction. So you know exactly how to do it in Jordan's. You're basically, the more you work, the more you owe in a certain way here, which seems troublesome. So why don't you address the three different facts, the one that helps you and the two that don't look so good.
Understood. So the Sleepy's pay plan, $125 per day. It did not track or pay out separate and additional overtime pay or Sunday pay. So what Sleepy's had to do.
And you didn't lose, you were given that money. You got that money. By the way, that wasn't enough, obviously. Money was yours.
It was the exact same system as Jordan's. It was a draw against future.
They had no subtraction, did they?
They did, Your Honor. In the Sleepy's case, what
Would
Sleepy's
fall behind and owe money, meaning you went and got your payroll in that week, you would still owe them money that you had to pay back out of future commissions?
The $125 per day in Sleepy's, well, the way that the plan operated was that Sleepy's admittedly didn't pay the statutory pay that was due, the overtime pay, the Sunday pay. Sleepy's argued, we're going to pay commissions later, and we're going to retroactively count some of those commissions towards that we failed to meet. We failed to pay the Sunday pay and the overtime. So there was that retroactive application.
But if in that time period you earned commissions, they would subtract, like have it be a constantly ever accumulating debt, right? That it was, maybe I'm wrong, but
my understanding of the Sleepy's pay plan was that it operated identically. The $125 per shift was a draw against future commissions. That concept is the same at Jordan's, but slightly different. It pays out a base hourly rate to employees. We pay the minimum wage times 40 hours. We pay a separate and additional payment that shows up as a line item on the pay stub.
it's a draw. It's not you're giving.
The draw
no matter what,
is
you have to pay it back, right?
Draw is specifically defined in the Jordan's pay plan, and the definition of draw is an hourly base pay designed to provide sales employees despite fluctuations in commissions earned. So at Jordan's,
That's how it's described, but that's not how it actually works. When it works is if you work that overtime and get that draw, you got to pay that money back out of your commissions. You don't get to keep that money. You have to pay it out of commissions back, right?
And that was the same system in Sleepy's. And so in this case, the draw was specifically defined in the pay plan, and we received an opinion letter from the DOS in 2003 that specifically said that that was permitted. Question number 6 was, can the employer count the premiums paid to the employee as a recoverable draw against future commissions? And the answer was yes. The Attorney General continues to take the position that that is permitted. In topical outlines that the Attorney General's office publishes every few years, the most recent of which was
Counsel,
published.
can I ask you to address how the Jordan's Furniture Plan meets the goals of the overtime statute, the 3 goals that are set forth in Mullally?
Yes. Of the $9 million judgment in this case, 97% is Sunday pay. Only 3% is overtime. Mr. Sutton, the plaintiff in this case, worked fewer than 5 minutes of overtime during the 3-year window at issue in this case. A full 1/3 of the class members, the average overtime of the class members over that 3-year window was only 4 hours. There's a reason for that. Jordan's testimony, which is in the record, was that they did not schedule employees to work. In fact, they dissuaded employees from doing so, and that's why it was such a rare occasion. And so this is not a case where this employer is seeking to avoid paying extra pay for employees working longer periods of time behind the overtime statute. So the overtime statute in this case applies to only 3% of the damages. The relevant statute is the blue laws. Chapter 136, Section 6, paragraphs, the payment obligation with respect to Sunday pay. That statute is 4 sentences long. The first 2 sentences create the obligation to pay the Sunday pay. The 3rd sentence says the attorney, this paragraph. The 4th sentence says that the fines that are available under Chapter 149, the Wage Act, Section 180A, are available to enforce the blue laws. So for 97% of this case, it is Sunday pay, which is governed by Chapter 136, Section 6, paragraph 50. And there is no private right of action under that statute.
So can you address the argument, I don't know who made it, that the Wage Act gives that private right of action to collect wages, and so including Sunday pay?
Yes, Your Honor. Chapter 149, Section 150 of the Wage Act creates the private right of action. And the first sentence reads that an employee who is aggrieved by a violation of 12 specific statutes that are listed out in Section 150.
And I take it the 12 do not include the Sunday.
It does not include the Sunday pay law. And obviously that was intentional. This court, in the decision that it issued in Donis in 2020, said that that language is controlling, where Section 150 has a specific list of 12 statutes, violations for which can create a cause of action under Section 150. We have to follow that language. This court, in the decision, said we will not override the will of the legislature by reading into these statutes additional protections for employees that their authors did not choose to provide. The Sunday pay law for decades has been enforced by the Attorney General's office. Today, an employee can go online, fill out a complaint form, claim they weren't paid their Sunday pay, and the Attorney General pursues that claim on their behalf. That's the reason why we have cases like Driverama versus Attorney General. In that case, the employee went to the Attorney General, filed their complaint for Sunday pay. The Attorney General ordered the employer to pay the pay, and then the employer then filed a lawsuit. And that's why the 2 parties there are Driverama versus Attorney General.
Ms. Brennan, I'm not sure how much the 97.3% really resonates with me, and for a couple of reasons. One is there's a lot of money in this case.
Yes.
And number 2, depending on what the retroactive analysis is, it might be really a lot of money. And 3% of a really a lot of money. So the public policy concerns about people not working too many hours and also other people having opportunity for jobs is present in this case, because 3% of a lot is a lot and 3% of retroactive a lot.
The relevant public policy in this case is the public policy behind the blue laws. And that's why it's important for this court to understand that the 97% pertains to Sunday pay under the blue laws.
Can I
So-
read you the AG's brief, give you a chance to respond? Argument, but that ignores the fact that Section 150 explicitly includes violations of 148 in the list of statutes for which it grants employees a private right of action. The next sentence key. The fact that GLC 136.6, Section 6, the blue law, is not a new event, because as explained above, that statute only determines the rate at which employees who work on Sundays must be paid. The failure to pay that rate is actionable under the Wage Act.
I disagree with those statements, obviously, and let me
Why don't you
explain
say why?
Section 148 is a statute that requires the timely payment of wages. Wages is not defined. This court has held repeatedly that just because an employee claims that wages are due or some amount of money is due to them from their employer, it's within Chapter 149, Section 148. This court has repeatedly narrowly interpreted that to exclude things like money that is supposedly due under the prevailing wage statute, or discretionary bonuses, or contingent commissions. There are many compensation, and particularly, most recently, in this court's decision in the Zucchini Gold case, an employee sought to pursue a Wage Act claim where the origin of the obligation to pay the time and a half was the FLSA, a different statute. In that decision, this court said wages is not all-encompassing. Of the obligation to pay that overtime comes from the FLSA. The employee can't shoehorn that into a Wage Act claim. That same analysis applies here. It is only under 136, Section 6, that an employer has to pay Sunday pay with no obligation to pay premium pay.
To whom does the employer have to pay the Sunday pay?
The employee.
Okay, and it is for what?
It is for pay on Sunday.
For working on Sunday?
For working on Sunday, yeah.
Wage. An employer must pay an employee for work done. How is that, in what world is that not wages?
In the world where this court has determined that wages has a very specific definition.
Have we ever said does not include the payment, the compensation owed to an employee for the work done?
Yes. So, for example, in the Zucchini Gold case, the FLSA creates the obligation to pay time and a half in that case. The employee sought to bring a claim under the Wage Act. This court said wages, the word wages in that section is not all-encompassing. And because the origin of the obligation to pay that time and a half is in the FLSA, not under Massachusetts law.
Well, wasn't that case really about whether or not you treble the damages or you get to double them under the FLSA, since the cause of action arose under that one?
No,
it wasn't about wages not being compensation for work done.
In the Zucchini Gold case, because it was a restaurant, restaurants are exempted from the overtime requirement under state law. The employee had no basis under any Massachusetts law to pursue a claim.
Right, and so the question was only whether the federal law provided the remedy, or if the state law could be used as a vehicle to override the state law, presenting a supremacy clause problem, right? You don't have that same issue here.
Well, the same analysis has been used with respect to various types of compensation that an employee can claim an entitlement to. So, for example, where an employee claims an entitlement to wages under the Prevailing Wage Act, the Prevailing Wage Act creates the obligation to pay that pay, which is the Donis case. The employee can't then, even though the central thrust of this case, and that's the language that's used repeatedly, the central thrust of the claim is under the Prevailing Wage Act. In that case, this court said, because the Prevailing Wage Act creates the obligation to pay, you have to look to the Prevailing Wage Act for your remedies. You can't label it something other than what it is. It's a claim under the Prevailing Wage Act, and therefore, you can't use the Wage Act to call it something different. In this case, in count 2, that's exactly what the plaintiffs did. The Sunday pay is only due under Chapter 136. That is the only place in Mass General laws that creates the obligation. And it also creates the remedy. That third sentence says the Attorney General shall enforce this section. And the Attorney General does, in fact, regularly enforce that section. If I could.
Can I get you to issues? Because they're not so simple either. Let me do this, the shorter one. The lodestar, which I think you have a better argument on, that there's very little analysis of why this is done time.
That is correct, Your Honor.
And why don't he's going to stand up and argue the opposite. Why don't you address why that's wrong, what the judge did on the lodestar?
Yes. Court's Unistar method should be applied with respect to a fee-shifting claim like this is. And the lodestar method is for the judge to determine an appropriate number of hours for which attorney's fees will be paid by it. And every case that you look at under any of these employment statutes, the judgment or the order is for that amount of money. There's never a multiplier applied. So to the extent that we're challenging the fee
So
award.
here, the judge multiplies the rate or the hours times 4?
He performed the calculation to come up with $160,000. So he analyzed how many hours and then analyzed the rate, said it comes out to approximately $160,000 without any explanation or support or authority. He said, I'm going to multiply that by 4, and that's going to be the fee award.
So these people were billing out at how much per hour?
I think the approved amounts were 400 and 500, and we're not challenging the amount
So
of
they're
the
billing
rate.
out at 400 and 500 an hour, and how many hours did it take to bring this case?
400 from beginning all the way to judgment.
And the judge gives a multiplier. What is his explanation or her explanation for why it's times 4? Because I can't remember what it is.
The judge somehow looked to a bunch of factors that are applicable in a common fund settlement case, which don't apply in a fee-shifting
And
arrangement.
why do they do it in a common fund case? Why do they multiply it by 4 in a common fund case?
So when we settle a class action wage in our case, usually counsel agrees to an amount that's going to go into the common fund, and then we negotiate what percentage is going to go to plaintiff's counsel. In order to get that class action settlement, we bring the settlement before the court, and the trial judge analyzes, because the trial judge has to act in the interest of the members of the class who are not present, to make sure that the contingency fee that's being taken from that common fund is appropriate. That's an entirely different analysis than the lodestar methodology that applies in a fee-shifting arrangement.
Okay.
And so we're not.
You're over. So can I ask you about the retroactive? One question, Chief, with your permission. So the regulation is not the problem. This policy guidance thing is ambiguous enough that it can support your position somewhat. But we normally apply statutes, as if we don't requesting, and we need an exceptional reason. Is that alone the exceptional reason? Because, somebody in the department issued guidance that may very well be inconsistent with the regulations, but supports your position?
I think there are quite a few reasons activity shouldn't apply in this case. In this case, Jordan's was the good faith employer in 2003 that said to me, we want to set up our commission plan in a manner that complies with the law. I went and started communications with Lisa Price, said let's figure out how to properly structure this. As a result of that, she suggested
DOS is
Division of Occupational Safety, which at the time was the government agency.
so it's not the AG's office of the Department of Labor. It's this division of out this policy guidance.
I also received a letter from the Attorney General's office a month later, which was not in the record in the Sleepy's case.
Is that in our record?
It is in the record. And the Attorney General's office agreed with the advice that was given by those two letters.
And when we read those letters, do you reference the subtraction process in that letter? That you not only, that you can recoup all of this by subtracting it from commissions? Is that in those letters that we get?
Question 6, I specifically asked the DOS to weigh in on whether a draw could be applied towards commissions, because we were trying to structure this in a way that was appropriate and compliant with the law. We followed that advice, right? We incorporated.
And that the subtractions go forward?
Yes, yes.
Okay, okay.
Yes.
We'll read the letters. Okay.
Yes. And to this day, the Attorney General's office continues to say that a draw system like that is perfectly lawful and appropriate. We cite to many cases.
How can, I beg to, maybe that is, we don't have the AG argument, but the AG's brief says the opposite. So how am I going to know that that's the case? They're saying what you do is fine, even though they're arguing against you in the case.
In 2023, just 2 months ago in August, the Attorney General published, it's a summary of employment laws that the AG's office periodically publishes to give guidance to employers. Just 2 months ago, in the topical guidance that they published, these are the two statements that they.
It's in our appendix.
After we filed the appendix in the briefs, but it is attached, or excerpts of it are attached to the Retailer Association of Mass briefs. But these are the two statements that, as of August of 2023, the AG is still making to him. Paid as a recoverable draw may reduce future commissions, provided the employees always receive at least minimum wage for all hours worked and overtime compensation when their hours exceed 40 in a given work week. They also make a statement, 100% commissioned employees must be paid at least the equivalent of minimum wage for the first 40 hours and time and 1/2 minimum hours worked over 40 in a given work week.
Can I ask you, do we have cases that say that our analysis or the application is prospective as a matter of fundamental fairness in other statutory cases?
Yes, so it's a 3-part test follows, and it looks to whether there was reasonable reliance. That's the first factor, and Jordan's easily meets that given the opinion letters that it relied upon, the Attorney General's advice as of 2 months ago that it relied upon. The second factor is whether the legislation would further the purpose of the new interpretation. Keep in mind, Sunday pay in this state is now gone. It was phased out as part of the grand bargain legislation that was adopted in 2018. And as of January 1, 2023, make that point because employees are not going to lose any rights under the, if this court were to determine that Sleepy should be applied only prospectively. The statute of limitations is 3 years. So right now, if an employee claimed that they failed to be paid Sunday pay, they'd be limited to going back only 3 years. So the relevant window would be October 4th, 2020 to today, October 4th, 2023. So if this court were to rule that the Sleepy's decision back in 2019 can only apply prospectively, the that would be potentially impacted is if there's a current claim pending like Jordan's. And so Jordan's certainly satisfies this third criteria, which says that if an injustice would result from the retro statute or a new interpretation of the statute, then this court will on occasion say that it will apply only prospectively. So let me give an example.
I just want to make sure I understand that. So Sleepy's is issued in what year?
2019.
So Sleepy's, Jordan's continues to do this, right?
Only for a very short window of time. So the lawsuit that was filed by this law firm that represented Sleepy's in that case was filed in June of 2019. Immediately, Jordan's changed its pay plan.
Looking at the period 3 years before that lawsuit?
Yes.
Okay, so that 2016 to 2019 period?
Yes.
Post-Sleepy's, but
Correct.
Okay.
And as a result of Sleepy's, I'm sure many employers revisited their commission plans and changed them as a result of what was an unforeshadowed new rule. And within months of the Sleepy's case coming down, in hundreds of Sleepy's cases filed against retailers in Massachusetts, almost every car dealership, every furniture retailer was sued.
And every one of them has won, apparently, except for, and Jordan's is the last fighting this, is that right?
There are a handful of cases that have been dismissed for a variety of reasons.
Are there any cases going the way you want? Any Superior Court cases or anything out there going your way?
I have found that most retailers didn't do what Jordan's did.
Fight to
Most
the end.
retailers follow tracking or paying separate and additional overtime and Sunday pay. Jordan's did it differently. And Jordan's decided, we're going to pay a base rate of pay that's equal to the minimum wage, a separate and additional payment for overtime, and for Sunday pay. That makes all the difference, because as soon as we made those hourly payments, our entire obligation to pay statutory wage was done. We had completed and fulfilled that
Hadn't
obligation.
subtracted, but that's a whole separate story. Okay.
Okay, are we all set?
Thank you.
Thank you. Okay, now Attorney Cassavant.
Chief Justice and Associate Justices, may it please the court, good morning. My name is Brant Cassavant. It's been my privilege to represent the plaintiff, Matthew Sutton, and the 250-plus Jordan's Furniture sales employees who are the class members in this action. Address three topics, all of which have been touched upon here today. The first is why Jordan's pay plan absolutely does not comply with the overtime statute or the wage laws, as this court has interpreted them in cases like Sleepy's. Second, affirm that Sleepy's does apply retroactively to conduct arising prior to the date of that decision, as most of this court's decisions do. And third, I would like to explain why plaintiffs have a private right of action under the Wage Act to recover unpaid Sunday premium pay. So fundamentally, did Jordan's pay plan comply with the wage laws as those laws were interpreted in Sleepy's? The Superior Court held it did not, and the Superior Court was 100% correct. In Sleepy's, this court relooked at the plain language of the statutes, the regulations, the case law, and concluded the following. Draws and commissions cannot be retroactively allocated as hourly wages for overtime and Sunday, even if those draws and commissions equal or exceed what the employees would owe.
Here, the draws were not retroactively allocated. It sounded like, if I understand the program, Jordan's paid employees for their first 40 hours at the minimum rate wage, which Sleepy prescribes, and then any overtime at time and a half.
Incorrect, Your Honor. What it would actually do is this. Jordan's informed its sales employees that they would earn their commissions. They explicitly use the phrase, earn your commission, when an item was sold and the customer left the store with it. Or Jordan's would then would purportedly pay the commission earned on that sale in week 1, in week 2. Now, what Sleepy's would require is that Jordan's pay the full value of that commission, plus any additional sums, not on a draw basis, for any Sunday hours or overtime hours that employee worked. But that's not pay.
Where does Sleepy say that?
Yeah,
Sleepy's in Dixon.
Sleepy's is harder for, Sleepy's is different from you in one respect. They just paid $125 a day. They didn't do this division, right? They just paid $125 a day. Jordan's, right, they do divide it up, right? Mm-hmm. They do have an hour regular pay, Sunday pay, and overtime pay. Now, they don't really give you a check for that, right? They do something different, but it is different than Sleepy's.
It is different from Sleepy's, but I have to emphasize, the difference between this case and Sleepy's is completely immaterial. The fact that Sleepy's paid a $125 draw plus any commissions earned in excess of that draw, which was actually how Sleepy's paid people. Almost exactly how Jordan's did it, except Jordan's calculated the draw by the hour. So
So why doesn't that comply with Sleepy's?
It doesn't comply with CPs because the hourly draw is still coming out of the employee's commissions, their earned commissions. So they earn a commission.
Does Sleepy have a 100% commission employee?
No. Under Sleepy's, you can have 100% commission employees for
You
minimum.
also have to pay them the minimum wage for the first 40 hours?
No.
Okay. Why don't I let you speak?
Under Sleepy's, you can pay a commission on a percent commission basis and use those commissions to satisfy your minimum wage obligations. What you cannot do is take those earned commissions earned in 1 week and then the next week withdraw a portion, hold back a portion of those commissions and we're paying you for the overtime and Sundays that you work. So the way that it would work is if an employee in 1 week was owed $1,000 in commissions and $200 of that and was owed $200 in Sunday pay, let's say. So in total compensation, what Sleepy's would require in that instance is a $1,200 paycheck, which could include a draw from minimum wage, plus separate an additional
can I-
$200 paid for Sundays.
Because I'm behind you a second. So I'm a Sleepy's employee. I go to work. I sell beds or whatever I do there. And I don't sell a thing that week. Do I get a check for that week? Or are they paid on a bi-weekly basis?
Jordan's?
Yeah.
They were paid on a weekly basis.
So at that week, I haven't sold a thing. Do I get, but I worked overtime. Do I get a check that says that I worked this many hours and this much over to that? And okay, and then the next week, I still haven't sold anything. So I get a check for my salary, my regular hours and overtime. Now owes Jordan all that money, right?
Yes.
And that's the difference. When I worked at Sleepy's, I got a check for $125 a day times 5, and I didn't, no matter what, but I didn't owe anything, right? Or did I owe Sleepy's?
You did
stuff?
owe Sleepy. I think the essence of this confusion comes down to this, is where the money is coming from and whether the employees are actually getting more money for having worked more hours, meaning overtime hours or Sundays. Under any...
But okay, but let's pin that down. Sleepy's, they clearly didn't, right? There was no doubt they didn't.
Yep.
But an employee at Jordan's who that week got a check that had more money than an employee who didn't work overtime, right?
Correct, yes. But then that money would be recovered from future commissions.
So that's where, I think that's where it gets harder, because then you're getting into another part of Sleepy's, which says that money needs to be secure and separate. And it's like Jordan's does do that for this special holiday pay. In footnote 8, there's a group that gets exactly what you're talking. There's a type of pay that's paid for that exactly.
Yeah, there are certain holidays that Jordan's paid separate and additional from any draws or commissions.
And they didn't subtract from
And there was no
commissions.
subtraction from the commissions. This really...
So if they didn't subtract, if you got that check every month from Jordan's and they didn't subtract later, would that have satisfied Sleepy's?
Arguably, yes, because it would be separate from and in addition to any of the draws or commissions that the employees owed.
Can I ask you, and you used the phrase essence of the confusion and had a great exchange with Justice Kafka. Doesn't this really illustrate why this should? Because part of the three-part test looks to unfairness and foreseeability, whether something's foreshadowed. And we have DOS and the AG's office given opinions. We have this confusion that you were just illustrating. Why shouldn't it be prospective?
To get some of the essence of the confusion that I referenced, it was not the essence of confusion of whether Jordans should get a pass for having flagrantly violated the law for the past several years on what is basically a good faith affirmative defense, which I would like to get to. It is the essence of the confusion is that we're using complex industry terminology like commissions and draws. In Sleepy's, this held in a single sentence unanimously. Employees are entitled to separate and additional payments of 1 1/2 times the minimum wage for every hour the employee worked over 40 on Sundays. All of Jordan's sales employees' compensation came in the form of a commission, which is sales earnings, from which Jordan's would deduct sums that it was paying them, that it was advancing them for the overtime and Sunday hours they were working. So an employee, if you have an employee at Jordan's who works a particular week and works a Sunday and makes $1,000 in sales, the next week that employee is going to get $1,000. Jordan's would allocate that $1,000 between a draw, which was an advance against the commissions they earned, plus whatever commissions were left over after the deduction of that draw. Let's say you had another employee work the same week, but not work Sunday, and also in pay. That employee
But
is...
he wouldn't earn $1,000. His draw would be lower, right? His draw would be lower than the employee who worked overtime.
But he would still earn $1,000. He would earn the exact same amount as the employee who did work Sunday, because they both generated $1,000 in commissions. Jordan's would carry those commissions forward and then would deduct the draw from that. It's just that the employee who worked the Sunday would have more of a draw taken out of the $1,000 less of the excess.
So the employee who worked overtime and the employee who didn't work overtime would get paid the exact same amount.
Exactly,
And
because
that's the problem.
that's the key. That is the key to Sleepy's. The key to Sleepy's is that the legislature, in its wisdom, and as this court noted, the legislature chose the carrot, not the stick approach to assuring compliance with the wage laws. And with respect to the overtime and Sunday pay law, what the legislature wanted was for employees to receive more pay for the burden of a longer week or for working on Sunday, believed people's times would be better spent with family or resting or so forth. A system that ensures that employees don't actually receive more pay for working more hours or on Sundays does not comply with Jordan's is cleverly implemented this system where the employees' earnings were capped at their sales earnings. They would only make as much money as their sales earnings, but Jordan's would cannibalize more of those sales earnings in the form of a draw to cover its premium statutory obligations.
Well, they could keep working and working and working. They would just they'd build up a debt that's higher, right?
Exactly, yes.
So they could get a higher draw. They could keep raising their draw, but they would also raise their debt.
Exactly, yes. It was basically Jordan's system required the employees to pay for their own hourly labor. And then once they had earned sufficient draw to cover that time, which Jordan's would take out of their earned commissions, Jordan's would pay them whatever commissions were left over after that recovery.
So back to Justice Gaziano's question. So I understand the regulations said that's a no-no, but they're issuing this department that your opposing counsel is communicating with is issuing statements that say, if you do this, you can pay it out of your commissions. If you pay this amount for hourly and you keep track of overtime, you can use commissions to pay for it. Now, they may not be fully informed of sort of all the cleverness of this, but does that give them, I mean, you call it a good faith defense, but it's not clear, right, that this is a no-no?
There's a lot of things in the law that aren't clear, and this court consistently applies its statutes retroactively, notwithstanding that fact. A couple points on these
But
letters.
the Pioneer brief brings up a couple of cases where even in the statutory context, right?
Certainly, yes, but this is not one of
doesn't
those
fit.
cases. To address these letters, one, I would encourage the court to look in the record and read the letters again, including Jordan's requests for these letters. One of those requests is not even a request for an endorsement of its current pay plan. The question in that case was whether an employee who worked in two different roles, how would you compensate them for working those two different roles? So that is completely off in left field. The other two letters, as this court looked at and read in Sleepy's, cause some confusion, but no direct conflict with the statute, and include numerous statements that a reasonable party or reasonable lawyer might read and say, this is still a little ambiguous.
But it was easier in Sleepy's because there wasn't any carve-out. Sleepy's just is $125 a day. They didn't have this breakdown that starts looking more like what that guidance letter talks about, right?
That's a form over substance position, Your Honor. So in Sleepy's, the employer did do what Jordan's did, which was advance them $125 and then pay them any commissions earned in excess of the $125 so that their compensation was always capped at their sales earnings. Their paychecks didn't separately itemize it, but the mere fact that Jordan's separately itemized what it indisputably employees' paychecks so that the paychecks reflected commissions earned in excess of the draw plus the draw payment, the harm is still the same. The employee is not getting additional pay for the burden of additional work.
It looks more like what that guidance letter said, right? It's paying commissions that total these two components, and they're broken out. So it looks a lot more like the guidance letter than Sleepy's did.
Certainly it does, but Jordan's reliance on those letters is of absolutely no moment. So I've called it a good faith. These executive agencies, it is not their job to advise employers on how to shape their pay plans. Indeed, in the Attorney General letter that Jordan's obtained, the Attorney General says in the very second paragraph, we don't have constitutional authority to tell you how to do this. This letter is purely informational. This court decides what the law requires, not executive agencies. And in that regard, Jordan's going out and soliciting these opinion letters is arguably no different than any employer hiring experts in a particular field and asking them what their opinion is of something. And then
Well, it's a little
when they get
different because
sued,
they actually go to the, we tend to, we talk about the deference that's owed, and we don't, again, those guidance letters look inconsistent with the so in Sleepy's, we're not quite as deferential to that kind of stuff as we ordinarily are.
I would argue that these letters are not in conflict with the statute at all. In the 2003 letter, the DLS noted specifically that inside salespeople are subject to state overtime law, even though the commission they receive is not included in the regular hourly rate for overtime purposes. Jordan's elides that statement entirely. Jordan's has always taken these letters and engaged in where the letters themselves are, as this court observed, somewhat ambiguous and are not models of clarity. Jordan somehow managed to divine perfect clarity out of them, and from that ambiguity said, oh, our pay plan is entirely compliant. We have done nothing wrong, and we have, notwithstanding the fact that the regulations were subsequently amended and revised, and decisions like Dixon and Mullally came out, which foreshadowed this court's decision in Sleepy's, where the court held employers can't retroactively reallocate wages for one purpose to another purpose. Setting all that aside, it decided to enforce our plan. That's a good faith defense, and there is no good faith defense under the Wage Act. This is a strict liability statute. But even if you engage in the retroactivity analysis, they can't prove any of the three prongs. This outcome clearly was foreseeable in the sense that this court, any precedent, reverse any of its prior decisions, hold that the letters or the regulations are in conflict with the statute.
Is that what, and again, the cases in one of the amicus brief where we don't apply a statute retroactive, were they all cases where basically we reversed ourselves or some more clarifying a very confusing area of the law?
Yes, the case law, the cases where the court has done this have involved situations where it has been revisiting prior precedent, or maybe is dealing with a regulation that is directly at odds with the statute, which is not the case here. This court held that the regulation is not intended, looked at the regulation as a way of arriving at its conclusion in Sleepy's. But then just to the other two quick points, because I see that my time is done, with regards to the retroactivity, the other two elements in this analysis are whether applying the case retroactively will advance the purpose of the overtime statute and the Sunday pay law is to ensure that employees receive compensation for the burden of the work that they've done. These 258 Jordan sales employees have worked $8.8 million worth of Sunday hours and overtime hours. Paying them that money will obviously making sure that they are ultimately compensated for the work that they do. Jordan's response to that is, well, we can't fix the past. I mean, we can't have them work these hours. And by the way, the Sunday law has been legislatively abolished. But that's a nonsensical position, as every other court to address this precise issue. Past may be unfixable, but this court can award damages, and that is in furtherance of the statute's purpose. And then lastly, Jordan's has really stridently argued that it was a good faith employer, it was trying its very best, and that it's untrue. Jordan's Furniture has never, in this case, provided a single iota of evidence that requiring it to pay its employees for hours that they worked is an undue hardship for Jordan's, a multi-million-dollar company owned by a multi-billion-dollar conglomerate that has fought this case quixotically from the beginning.
The Lodestar I don't get how you get four times your rate and your hours. Your rate seems fair, your hours seem fair, but,
So
and you've
in,
been very successful, but why do you get four times? It just almost no explanation for that.
well, there was plenty of explanation in the briefing, and the judge simply said that he agreed partly with each side. We wanted a 5 times multiplier, and he did not apply a 5 times multiplier because it's an abuse of discretion standard. This court,
Hold it, but, so again, we don't say you do a good job, you get 5 times the lodestar,
yes, there are.
that aren't this common fund oddity?
I would dispute that common fund settlement analysis is an oddity, and I'm happy to address this if the court will indulge me. Held in LaChance versus Commissioner of Commission, a case we said in our brief from 2016, that the way that in a judgment case where a party prevails on judgment, the basic measure of a fee award is the fair hours reasonably spent on the case. Then, quoting this court, the judge may then adjust the lodestar calculation upward or downward in light of the results achieved. And the court, in that case and in several other cases that we said in our brief, looks at a variety of factors, including the contingent nature of the fee agreement, the risk involved, the results obtained, whether the impact of the case affected more than just one or two parties but had broader. We cited all those factors, we argued all those factors, Jordan's argued against all those factors, and this judge, in the exercise of his discretion, and who was the same judge who decided summary judgment, and so was very familiar with the case, was very familiar about how much work and dedication went into the case, looked at these factors and said, I'm going to give you a 4 times multiplier, which was consistent with several other cases that we cited here, both in and out of the class settlement context. We cite a case in our briefing where it was a judgment, and the court, in very similar circumstances to this multiplier, evaluating these factors. And then very briefly, in the settlement context.
In that case where you got 4 times, what did the judge say merited the 4 times multiplier?
That it was a large institutional defendant against an individual, that it had a impact to a broader group of people. It was a consumer-style class action, and other outcome you reached. But the court in that case did apply the factors that I was looking at. And then very briefly on this common fund issue, yes, courts apply these similar factors in evaluating whether a fee award in a common fund class action settlement is fair and reasonable, but the are basically the same. The courts want to check against the amount of money the plaintiff's attorneys are asking for, whether it's fair and reasonable, taking into consideration the court's interests in encouraging settlement, that attorneys who take fees, skilled and intelligent and able attorneys who take fees on a contingency basis and who wait years ultimately receive the fair market price for their services. There's a district court decision we cite in our briefing where the court specifically said that it would be irrational in our market-based fee shifting system for a prevailing attorney.
Can I ask one last question? Sleepies, a fee in sleepies as well?
So that was on this court in a certified question, but then it settled when it went back to the district court.
Okay, so we don't have a decision.
There was no judgment there. So with that, I say my time is concluded unless your honors have any other.